All right, and moving right along, and I think we're going to stay on schedule. Let's see, I'll take this clicker. This one? There we go. So this is my favorite slide. I had to match Juan's money slide with a cake slide. And just to amplify a little bit of what Juan was saying yesterday about the underpinning of all the work that we do, and that is promoting efficient markets. The price cake is really the concept of all the information out there gets baked into the price of a security. That's the whole idea. And if the public doesn't know some of it, the price will be wrong. So it's essentially, if you go to buy a car and you think you're buying a new car, but what you really get is a used car with a broken transmission and flat tires, you've probably overpaid for that car. And you've also overpaid for securities when you're buying something without all of the unpleasant news disclosed. And the markets are pretty efficient. They work very quickly, and of course with technology, they're even more efficient these days because everything happens almost immediately. So with that in mind, let's talk about the kind of money that is at stake in securities litigation in the U.S. and also abroad. Government and versus private enforcement, we'll get to. Let's see, what am I? There it is. Yeah, government versus private enforcement, and why we all need to be thinking about this stuff. So this is a list of just a representative list of the biggest cases that we've seen in class actions in terms of settlements. And why do we care about settlements, by the way? I'll tell you, because they almost never go to trial for one simple reason: they're too big. Companies do not want to bet their future on losing a trial. Trials in the United States are incredibly fraught and uncertain because they're mostly jury trials. And I can tell you, having dealt with juries and mock juries, that they often have no idea what they're doing. They are more focused on your color of your tie sometimes than what you're saying. And it's a very scary prospect to risk a large public company's future on that. At the same time, from the plaintiff's side, our job is to get as much money as we can for our clients as quickly as possible. And so we look at these cases really as a business deal where everybody's job is to evaluate the risks and the rewards and come up with a solution. And the solution in some of these bigger cases is a very large solution. I can tell you that these are the highlights, but there are dozens and dozens of cases that are in the hundreds of millions of dollars. There's a lot of money to be recovered and a lot of money for lawyers to earn while doing that recovering. So why do you need private enforcement? Because public enforcement really doesn't exist. The financial crisis saw the U.S. government, the SEC mostly, the Justice Department, bringing a few token actions against each bank, maybe pursuing a couple of hedge fund traders for insider trading. But for the most part, there wasn't any real punishment for the massive wrongdoing. An example, a case that we did in our firm, we represented a class against Citigroup. Citigroup had concealed their exposure to subprime instruments and things like that, like really all the other banks. And this is at the same time they're all suppressing their LIBOR rates to try to protect their reputations. And this all led to class actions. There were two. One of them was for equity holders. We settled it for almost $600 million. The same exact case happened. The SEC got $95 million, and that didn't go back to investors anyway. It just went to the Treasury. And Citibank really wasn't worried about that, but they were worried about these class actions. They paid another $600 million to bondholders. And this story played out against every bank. Another example is that we pulled up, and again, we can keep doing this. Bank of America, there was a recovery of almost $2.5 billion privately. The SEC got $150 million. Just very small stuff. I think the judge in the Citigroup case, as we had on the last slide, even commented on how paltry the settlement was, and he gave them a really hard time, but eventually that went through. The point being, however, again, that private enforcement is necessary, and there are opportunities out there for us to all do it and do it well. I can tell you from being on the defense side of these cases early in my career that Most of the time, you know, they did it, where there's smoke, there's fire. It may sound outlandish, but when you see some of the quotes from the chat rooms that David just pointed out, you know, the things that you think only happen in the movies, they really do happen. And so don't doubt it. And our clients, all of our clients are often victims. I should say that if our clients and your clients are issuers of securities, and on the other side of this stuff, there's a lot of advice you can give them to help them stay out of trouble in the first place. And I think you know, you owe it to them to do that. So now we get to a little bit more about the U.S. legal system and why we like it. As we heard yesterday, the European system is still kind of in its infancy in terms of collective actions. And collective actions are really the best and probably only way to deal on a mass scale with these problems. You couldn't have individual Forex cases that would really make a difference. It would be nice for a particular client, but it wouldn't really have a deterrent effect. You certainly couldn't have these basic securities cases without class actions. And why is the U.S. system good, and why do I not think it's leads to abusive litigation? Well, let's go through it. So first of all, there's no upfront cost to the client. The out-of-pocket expenses, all of that are generally handled by law firms like ours, who have an incentive to take risks on these cases. And we pick good cases. The whole idea is you pick a good case, because if we didn't pick a good case, we'd be out of business. And so that's really the number one incentive for not bringing abusive litigation, because abusive litigation will usually get dismissed early in the case, before discovery, and we will all just wasted our time and money. So that's number one, and I think that I think for the most part, the cases that do go through are meritorious, and that's why you see these big settlements, because the banks and their lawyers are not stupid. And I shouldn't just say banks, all kinds of corporate entities. They're not stupid, and they would not pay for a case that made no sense. I can think of maybe one case in my career where early on the defendants came to us and said, here's a bunch of stuff, here's a bunch of documents, you really have it all wrong. And you know what, we agreed with them and we dropped the case. And that can happen sometimes. Because again, I'm not getting paid by the hour to bring a bad case, and they convinced me that was a bad case, but only once did that happen. Most of the time, not to be cynical, lawyers who are getting paid by the hour would prefer to litigate the case for a while and then settle it later. And that's also what happens.
And since I understand that you finance the cases,
yes,
because unless you obtain some sort of reward for your clients, you don't see any money.
That's right.
How do you fund them? I mean, do the partners of the law firm fund the litigation, or maybe there's some funding litigation or
Well, mostly we self-fund, and most of the firms, I think in our space, self-fund. However, litigation funding, as we will hear about, I guess, in February, litigation funding has exploded onto the scene. There is more money than they can find cases to invest in. I question, frankly, the investment strategy, because we know how risky these cases are. But they're doing it, and it's out there. So litigation funding is starting to come into the market. But I think for the most part, we've been self-funding for most of our careers, and I think there's a place for litigation funding, but not too much of a place, because it can be very expensive for the law firm. So we'll see how that develops. So the client, however, is not paying anything. The client is not paying fees or expenses or anything like that unless they recover, in which case they will pay a percentage. Importantly, the U.S. legal system allows for contingency fees. Now, I think it's a little uneven in Europe. Mostly it's not something that's allowed, but sometimes it is. Around the world, you see different rules as well. The U.S., it's clearly allowed, and I will tell you, to those of you looking at class actions in Europe, there is no way you will have a viable class action system without contingency fees. And there is no way you will have it with a loser pays rule either. So the U.S. has no loser pays rule, which of course is designed to encourage these lawsuits. The U.S., when this law developed over the years, really decided as a policy we want to encourage investors and other aggrieved individuals to bring these cases. And it's a policy decision. Obviously we agree with it, but if you don't want these cases to happen, then the loser should pay, because nobody will take that risk. It's very expensive. That's why you don't see many collective actions here. the process and the aggravation you have to go through to fund a big case and insure yourself against the risk here in Europe, especially in England, is tremendous. And so it's just a policy decision. If you like them, you do it the American way. If you don't want these cases, then just don't do them or make the incentive so bad that nobody will do them. And as I said before, all the incentives in the US are to force the law firms like mine to only bring good cases. Yeah.
One question.
Sure.
Is it up to you or up to some kind of decision of the clients you are representing that you accept an offer or not? Because
In settlement?
Yeah, in settlement.
Sure. So it's always up to the client. You know, there's no lawyer-driven litigation. There certainly shouldn't be. And as we've all begun representing bigger clients, they are, you know, they're even more insistent on their right to make decisions. So in our case, it's always up to the client. They can hire us, they can fire us, they make the decisions, and that's how it is. I've never really had a problem with it because usually our interests are aligned. And if we think it's a good time to settle, it's usually for the same reasons that the client will think it's a good time to settle. There's no emotional element to it that you know, skews your judgment in this sense.
But in the class action, you don't have one single client. So
Well, you do. So I'll get to that in a minute. In fact, let's.
Okay.
Yeah. So let's talk about that. Let's talk about how do class actions work. There's a famous quote from many years ago from a lawyer who later went to jail. He said, "I have the best job in the world. I have no clients." Right. So that all changed, as Juan mentioned yesterday. In 1995, Congress said, we want to, you know, we're going to change the rules, and only the biggest clients, the biggest investors will run these cases. So lead plaintiffs are appointed. I won't rehash that whole process because you heard about it yesterday. But I did want to talk about, you know, why would somebody want to be a lead plaintiff, and what do they do once they are a lead plaintiff? So the lead plaintiff is essentially appointed by the court, and in every class action you have lead plaintiffs. In the Forex cases, in the LIBOR case, in non-financial cases, there's always a lead plaintiff under what we call Rule 23 of the Federal Rules of Civil Procedure. So Rule 23 has certain elements. You have to have a lead plaintiff or several lead plaintiffs. They have to be adequate to represent the class, so they can't have some, you know, problem going on. They have to be typical of the class. They can't have, the defendant can't have defenses against the lead plaintiff that it doesn't have against the rest of the class. So for example, in a securities case, if you had a lead plaintiff that had inside information, and the defendant could say, aha, you knew about this stuff when you invested, that wouldn't be a good lead plaintiff, and frankly, it's probably illegal. So that's the sort of thing that that the courts will look at. Most importantly, and however, all the claimants, all the plaintiffs, and all of the class members have to have common claims. And so it has to be efficient to bring a class action. I mean, why did they come up with Rule 23 in the first place? So you wouldn't have, when everybody had the same claim, you wouldn't have thousands of cases clogging the court system and defendants, you know, having to sit for thousands of depositions and do everything over and over again like Groundhog Day. So Rule 23 was really designed to make things efficient for the courts and for the parties. And for that, you need representative plaintiffs that have things in common with the class and are typical and adequate. And the class action has to be superior to individual actions. And that's actually become a bit of a challenge for us. We spend a lot of time and money just getting classes certified, which is a reason, as I'll mention in a minute, see how much time I have. Oh, not much. Big investors often opt out so they don't have to bother with class certification. So real quick, why does somebody want to be a lead plaintiff? Controlling the case is important. Hiring the lawyers you want to hire. Not all lawyers are equal. You know, we think the client should always have the choice of doing that, and leaving it all, if you've got millions of dollars at stake, you may not want to leave it up to lawyers that you don't know. Let's see, yeah. Controlling the class period. I mentioned AT&T at lunch. I can tell whoever is interested some stories about a case against AT&T which contains a lot of these lessons. Controlling the class period is important. The time between when usually, as Juan mentioned yesterday, the fraud started, the misrepresentation started, and the truth was revealed, that's the class period. But it's often a moving target. It's subjective, and you can look at it a lot of different ways. And if you look at it one way, you might have big losses, and if you look at it another way, you might have no losses. So controlling the class period is important. Controlling the securities involved. does the class include just common stock? Does it include preferred? Are there bonds? You know, that can be a big deal too. And again, I'll talk about it at lunch for anybody who wants to know. If you've got bonds, you've got stronger claims than if you've got stock, and there are reasons for that. So you may not want to be lumped together with the stockholders. Controlling the settlement negotiation, controlling how the settlement, how much you get, and then how it's allocated. Does somebody from the beginning of the class period get the same as somebody from the end? Or does one get half as much as the other? There are lots of ways to allocate settlement funds, and the lead plaintiff decides. And so it's a very valuable right. So these are reasons why the mostly large US pension funds, and we've seen European institutions as well, they want to be lead plaintiffs. They want to control these cases. It's really not that big of a burden, but it can have some very valuable benefits. I've got some slides here on the consequences of misinformation, which this is just a graph from Enron. You know, remember Enron? You know, this is a very familiar, you know, trajectory in our cases. The stock is up and it goes all the way down, and sometimes it goes down in stages as more bad news keeps coming out. Sometimes it's all at once. You know, then you have, I'm not going to spend time giving you a tutorial on how to calculate damages, but suffice it to say, it's not simply your purchase price versus your sale price. It's complicated. You need lawyers to do it. There are legal elements and economic elements that go into it. And it's often the case, or sometimes the case at least, that clients think they have big damages when they don't, or don't realize they have any damages when they have a lot of damages. So once again, this is why they need all of us to help them with these things. And again, this is money on the floor. There was a statistic a few years ago about $4 or $5 billion with a B went unclaimed from class action settlements altogether, which is crazy, you know. And so there's a lot of money that that gets left on the floor, and there's no reason why it should get left on the floor. They should get that money back, and we should help them. Now, let's see. So, a couple of things real quick. I can give you guys details later if anybody wants. There are a whole host of roadblocks where you think you're going in a straight line to recovery because, hey, I'm a member of a class, I'm going to get some money back. But no, you're not, because in fact, those securities were not traded on a US exchange, for example. The BP litigation, British Petroleum is a good example. BP, British Petroleum. We may remember British Petroleum had an oil rig in the Gulf of Mexico that blew up. They made a nice movie out of that. And after that happened, everybody sued BP, including shareholders. Shareholders sued BP because we say, and we're among those shareholders, BP spent a few years lying about all the great safety things that they put into place after the previous explosion, which they never really did, and that led to this other, even worse explosion. So these cases are going on. However, most of the shares were bought on the London exchange, not on the US exchanges. And why does that matter? Because the Supreme Court, with really a dumb decision, decided that US securities laws would only apply to US exchange traded securities. And we have a couple of slides how this became relevant in other, non-10B generic stock cases. David can talk to you about these at lunch too, because we've got to finish. But it's one of many examples of why things, and this changes. One day you can have a claim, and then the next day the Supreme Court comes out with a decision, and you don't have a claim. There's this slide, again, which I'll gloss over, talks about time limits. A very sleepy concept called the statute of repose, which nobody had ever heard about. We've all heard of the statute of limitation, but the statute of repose came to prominence when the Supreme Court decided class actions would not, as we say, toll or stop that clock. And so the clock kept going. And so that started affecting individual rights to do things. And what does that mean? That talks about opt-out actions, individual litigation. I've discussed with some of you that I can see a world now that the US Supreme Court is so far to the right where Rule 23 and class actions will go away, or perhaps be greatly diminished, and therefore big investors at least will have to bring their claims on their own. which they can afford to do because they have big losses. It's unfortunate for small investors, but that may be the world we're headed for. And already big investors are bringing their own claims because you can often get more opting out or bringing an individual case than you could by being part of the class. And there are a lot of reasons for that, but the most basic one being the defendants can usually afford to pay a bigger percentage of smaller losses than a big percentage of class-wide losses. And there's a couple of slides which you can look at since you all have the handouts, which talk about, oops, that's us, which talk about the kind of entities that are opting out of cases. You know, you might recognize some of the names. You've got sovereign funds, you've got big investment firms, things like that. Pension funds do it. There's very little public information on what kind of recoveries they get. This slide has some that are public. I can tell you we've opted clients out and they can get 2, 3, 4, maybe 10 times as much. So there, sometimes there's a reason to lead it, sometimes there's a reason to opt out. The overarching lesson for everybody here is the clients deserve consultation so they can make an informed decision about what to do, as opposed to just doing nothing and perhaps losing out on some good opportunities. I'll probably not tell you anything you don't already know. We threw a couple of slides in here about the internationalization of securities recoveries. We're seeing it some more, but it's not that much. We do try to bring cases in other jurisdictions whenever we need to, but it's always better if you can get into the US court system. It still beats everywhere else, just because, as I said, the policy clearly is investor friendly, even though it's less investor friendly than it used to be a few years back. I'll note that the Trump administration is no fan of what we do, but in their zeal to deregulate everything, they are only making our lives better, because without regulation, without the speed bumps and the roadblocks, we will see even more abusive practices, and fraud is still fraud. And there'll always be claims for fraud, and lawyers, good lawyers like all of us, will always find ways to bring those claims. So keep your eyes open, because deregulation's coming, it's happening, and your clients are going to be victimized even more. David already mentioned these last couple of cases, and I think that is it. And this is us and what a good firm we are. But thank you very much. And look at that, only 5 minutes late. We'll go offline.